Good morning. Everybody today is attending a lecture on fettering of discretion. We're looking today at not negating a council or an ICB's discretion in relation to situations in which they have got powers or situations where they have got duties, but with a lot of wriggle room, supposedly turning on professional decision making. So, how is it then that a council's discretion could end up being fettered? We're talking about where a council is able to make a range of decisions, but is in fact decided in advance on saying yes or no, or has got a policy against which it makes very few exceptions in reality. So let's think about why we have policies at all in public administration. It's not just local authorities, it's ministers as well who have very wide discretionary powers to exercise, and these are usually conferred in statutes, and the Care Act is a perfect example. Where they have very wide discretionary powers, of course, they find it helpful to issue policy documents because that gives guidance about how they may use those powers in practice. And that means that they've got to have fewer people on the telephone explaining what the council could or would do. They can write up a policy. And policies can promote a number of objectives, and one in particular is making sure that a large number of council officers who've all got to make the same type of decisions with very different people coming in front of them, a policy is guidance for them so that they all know the direction of travel that the local authority is interested in. Now, if you put 20 social workers in a room and you give them a scenario, you'll find that you get 20 different answers. But there will be a core consensus, and there will be some outliers who will either be incredibly generous or incredibly mean about what they think would be enough, for instance, to solve that person's problem. So policies are important because they hold the ring in relation to staff extremity. And then that limits the risk of arbitrary, or what the law would call capricious, differences of outcome. That is, if the policy is well written. There's no obligation in public law for an authority to issue any policy at all unless it says so in a statute. But if a council does put a policy in the public domain, the idea is that it helps individuals figure out the hoops and the hurdles that they've got to get through. And it also provides some standards against which the public authority can be held to account, because a policy is not law, but it is still more than just an idea written on the back of a brown envelope. So policies are generally good tools for promoting good administration. They don't create legal rights as such. So if a council has got a power to do something and it wants to put a policy up for general consumption, the fact that it says what it will generally do does not mean then that one can force them to do that, because that would be turning a power into a duty. It would be effectively asking the council always to do what it said it was going to aim to do, and that is not on. But crucially, the other way round is unlawful too. So for a local authority to say what it generally is aiming to do, but for then that to turn into something that becomes a rule, when the policy hardens up into a rule, then it becomes over rigid. And when it just becomes like the quick way of the management controlling the staff by just saying, our policy is such and such, and that's what we're going to do, then the suggestion can be made that the policy has become fettered and that the professionals are no longer engaging brain. You know, they are not going through They're not passing through jail before they get to the decision, as it were. So councils have to be willing to consider whether their policies should or should not be followed in particular cases. And if you are someone's loved one or someone's advocate or a person drawing on services, knowing that councils must be prepared to make exceptions is a tool in and of itself. So what might some of these policies look like? Policies about face-to-face assessment, for instance, as opposed to online. Policies about resource allocation. Famously, resource allocation computer-driven algorithms for what should be enough money for a type of person, those were very fashionable before prices went through the roof. A really controversial policy is something called a maximum cost policy, or these days, an affordable cost of care policy, roughly translated into nobody can have more than the cost of residential care. We used to call that cost capping in the old days. Policies on consultation and reasonable adjustments related to the public sector equality duty. Very clearly, charging policies. You may not realize this, but under the Care Act, all charging is discretionary, and financial assessment itself is merely bounded loosely by regulations, and within that sphere, councils can have their own charging policies. What about this? Policies about who and what level of staff can make which decisions. For instance, about which tasks need a qualified social worker for competence to be assured. Commissioning policies such as this: we will only contract with 4 domiciliary care companies, not 14. We won't buy shopping, cleaning or transport as part of care plans any longer. We won't pay more than £850 a week for any care home bed. Anything else will have to be a top-up. Or we won't work with homes that ask for top-ups. All of these are typical commissioning policies, and commissioners don't end up getting any public law legal literacy training. So if these are dodgy, then they are being perpetuated around the country. I've got some examples here with direct payment policies. When is a direct payment in fact going to be refused as not appropriate? And on what should they be allowed to be spent, given that they were supposed to be, the vanguard of flexibility and innovation? What about policies that say when a council will accept that it's necessary for a person to be allowed to pay a close relative in the same household out of the direct payment budget? And then finally, I've come across policies about how widely to read the eligibility criteria. For instance, do we all accept that maintaining nutrition and hydration includes being able to shop? Or is there a policy in your local authority that shopping is not included, not as a commissioning policy, but as an assessment policy? So I'm hoping that that will set your minds thinking, and people will be thinking about questions to ask. The fact of the matter is that courts sometimes use judicial review to overturn policies when the policies purport to explain what the law itself is. So there are 3 types of case where a policy can be quashed by reason of what it either says or omits to say about the law. So the first type is where a policy that is issued to the public includes a positive statement of what the law is that turns out to be wrong. And when following what the policy says will induce a person to breach their legal duty in some way. Clearly, that kind of a policy has to be got rid of PDQ. The second type is where the authority which issues the policy does so because there is a duty to provide accurate advice about the law. But then it fails to do that because of a misstatement of law or because of an omission to explain the legal position in full. So, for instance, if you look at the policy guidance and you look up deliberate deprivation of assets, if the chunk in the guidance omitted to explain that just because you've given your money away doesn't mean that you've deliberately deprived yourself of your assets to avoid paying for care, that would be an example of a policy where, of course, central government has a duty to provide accurate advice about the law, but fails to do so. If a local authority did that, they too would have that quashed. And then the third example is where an authority isn't under a duty to issue a policy at all, but decides to issue one, and in doing so, purports to provide a full account of the legal position, but fails to achieve that, either because of a specific misstatement or because of an omission, which means that when you read it as a whole, the policy presents a misleading picture of the true legal position. And cost capping policies are the prime example of that. Several years ago, it must be at least 5 or 6 now, ICBs, which were then probably CCGs, or they may have even been PCTs, but I think that they were CCGs, they all went online at the same time and said that their policy was going to be that they would use residential and nursing home care if it was cheaper for people than keeping them at home. And the Equality and Human Rights Commission found a barrister who persuaded through advice that to have that policy in advance, even though there was no duty to say what the policy would be for meeting people's needs, to have that policy stated as a policy level without explaining that, of course, human rights would be taken into account. The Mental Capacity Act would be taken into account. The wishes and feelings and a professional view of needs would need to be taken into account. And whether, of course, there was even a vacancy would need to be taken into account. And whether best value considerations would be taken into account. The barrister persuaded the ICBs that they couldn't put that policy up lawfully. What they could do is state what they would generally be aiming to do to provide cost-effective care, acknowledge that it wasn't as black and white as that, and assure people that there would be no arbitrary cost capping applied to individual people. And that, of course, would have negated the whole point of saying that they even had a policy in the first place. So the most obvious example that springs to mind outside of cost capping is the recent BG and Suffolk case about the policy not to provide financial assistance to people for holidays. The scope of the CARE Act was the legal reason they put forward for their policy of not bothering to assess people in the first place for anything related to an activity. And that was judicially reviewed, and the Court of Appeal said there was no justification for a policy of that nature. It had gone further than that and had skewed even assessment for a whole set of people. So Suffolk had to go back to square one again. And I think that people will be interested to know that Suffolk was not the first time local authorities had tried to protect themselves from people having the temerity to say that public money should be spent on ensuring that disabled people got a holiday. Believe it or not, there is an old case from 2004 called North Yorkshire and Hargreaves. And of course, it's under the old law. It's not under the Care Act because the Care Act didn't exist then. North Yorkshire had a policy that they would pay for the carer to go with the individual. They would pay the carer's costs, but not the basic costs of the disabled person's holiday in and of itself. And North Yorkshire was judicially reviewed for saying that. In those days, the law was the CSDPA, and the duty was to facilitate a holiday, not provide it in full, but at least to facilitate a holiday. And the judge said that that means that a local authority couldn't discharge its duty without considering at least some provision for the basic cost of that holiday. The council contended, and you can imagine that this would be the law, the position of anybody now, that Parliament's intention was not to relieve poverty, because that's done through benefits, but to relieve disabled persons so far as possible of the added financial burden imposed by their disability. And it was said that if the council had decided that the need for the holiday was a result of the disability, then the cost of the holiday must at least be capable of being an additional cost, which was the result of the disability. So the beginnings of the Suffolk decision date back to 2004. In the Suffolk case, 2026, can't be 26 years later. Maybe this case was in 1990 something or other. I'd have to look it up again. I am not good at counting. In the Suffolk case, although it went to the Court of Appeal, at first instance, Beverley Lang, the judge, considered the authority of the Hargreaves case. And in that case, the council accepted that the disabled claimant had the assessed need, but would only meet the costs of the carer. And as we've heard, that was judicially reviewed. So in that first case, the judge was Latham. And Beverley Lang, in this case, all these years later, maybe a quarter of a century later, reminded herself of what Latham had said. The respondent's principal argument that the legislation was not intended to provide relief from poverty, but relief from the extra expense of disability, begs the question. If the council have determined, as in this case, that the need for a holiday is as a result of the disability, then the cost of the holiday must be at least capable of being an additional cost, which is the result of the disability. Although the question may well arise as to whether in the particular case it is necessary in order to facilitate the holiday to assist with that cost. Now, that is the bedrock of the decision in Suffolk. Put simply, she said, if the claimant's assessed needs arising from their disabilities include a need for a holiday or other recreational activities, then the cost of the holiday to the disabled person is at least a need which can be met under the Care Act. So Lynn said, I think it was Lynn said she was trying to argue for a holiday for someone. And she said a very significant thing. She said that the person has already had a holiday funded in September, and she's trying to get it made into an annual thing. It's a key feature that that person has been thought to be in need of a holiday before now. I don't know how soon the next holiday is supposed to be, but you can imagine what any council is going to say. Cost of living crisis, ordinary people don't go on holiday any longer, let alone more than once a year. And you can see that if a council knows about the Suffolk case, Lynn's council was Walsall, if they know about the Suffolk case, they know that they can't say that they will never fund a holiday. But they can say that they have to meet everybody's needs and that they can be less generous than the person wants them to be. So, for instance, when I tried to argue that a family should be able to go to Pakistan on public money, the local authority did not say, we won't pay for that. They said they thought it was too dangerous for the person to go that far, given her mental and physical disabilities. And that, therefore, made it kind of hard to argue back that that was an unlawful decision. In the end, the family went on holiday and had an absolutely marvelous time, but they didn't get any public money to pay for it because they had relatives who would pay for it if push came to shove. But it was a good idea to try first from the council. So a question as to whether you're going to get a holiday included in a care plan, and by that I'm talking about the basic cost of it, not the costs of the carer, which can also be in the care plan. It very much may well depend on how desperate the need is, whether it's a holiday that works for respite for somebody else as well, what kind of a holiday it is, and effectively, quite frankly, how posh a holiday it is, or whether it's a specialist holiday that can only be accessed because the person is disabled. So this is the link to the Suffolk case. And this is what the judges said in the Court of Appeal. Support under the Care Act can be comprised of pure financial assistance if there is no other way of meeting the need. As a matter of interpretation, it would be an error of law to construe the Care Act more narrowly. And the management view to the contrary had skewed a whole raft of assessments. So what does this mean? Well, it means that councils can't say as a general policy, we don't fund holidays ever as respite for an individual or their family carer. Nor can they say we don't fund activities. They're always for the person to fund themselves. And then and only then might we allow it as disability-related expenditure. They can't just say we don't fund trips abroad. As a matter of law, the inclusion of the word support into the scope of the Care Act function had broadened the remit of social services, and it was Parliament's intention that financial assistance could be included. It doesn't mean that everyone now gets a holiday. That's the key thing. You've done enough public law to know now that it couldn't possibly mean that everyone gets a holiday. The salient features in this case were that the persons receiving the services had had holidays funded as respite in the past. 2 men were concerned, and their mother was the only person who could adequately meet their needs, so she had to go with them. She couldn't afford to go without financial support, and it met the need that she had for her own role in that a holiday took some of the weight off of her of some of the ordinary daily living tasks, such as cooking and cleaning. So they went to America. But the Court of Appeal does make it sound as if that is a very narrow range of people who would be able to make their case that strong. For local authorities now, the only right way to deal with such requests is to focus on the domain to which the activity or the trip is regarded as relevant, focus on whether it's a cost-effective way of meeting that need, focus on whether there's any other way of meeting it that's suitable, and focus on whether there's any other reason why the council won't put public money behind that request. The likelihood in the vast majority of cases is that councils will be able to marshal a defensible decision that they will not pay for holidays. Let's look at a different type of policy now. This is the policy known as a resource allocation system. Local authorities don't let care managers and social workers just come up with the first figure that comes into their minds as to how big somebody's budget could be. Sometimes local authorities have commissioners who know what the cost of care is, and they allow the professionals to determine how much of any type of service in terms of time, or what type of service is required in terms of content. And then the commissioners goes and puts a price on it, and it builds up, as it were, in a linear way based on the professional judgment. I favour that type of resource allocation, I have to say. But in the 2010 to 2020 era, most local authorities bought into a resource allocation system that was much, much more sophisticated than actually looking at the real cost of care. What the resource allocation systems of that era did was figure out how much had been adequate to meet people's needs, and then compared features of people's assessments so as to be able to score them, and then tie a number of pounds to the points, so that you could say across client groups, sometimes in certain parts of the country even, you could say how much somebody who looked like this, or who felt like this, or who was suffering to this degree should cost in order to have their needs met to a level that must have been acceptable because the local authority hadn't been sued about it. You can see the problem here. These tools were tailor-made to enable a local authority that needed to cut budgets to say, let's change the figures at the top or the bottom of this program so that once we press one button, all the figures at the other end of the system for all the people change as well. It could still be a good system, but if you put garbage in, then you get garbage out. In this case, the lady was 70 and she had a whole swathe of problems. And she'd had community care support for 10 years and she couldn't leave her flat on her own. She did a supported self-assessment even before they existed. Please note, this is July 2009. And effectively, it was put through an early iteration of a resource allocation system. So she ended up being admitted to hospital before the sums had been run. And the social worker noted a decline in skills, but scored this lady's overall functioning at the same level. It's not very likely to be defensible, so they had another go. At the second stage, the authority determined that the resource allocation system would give this lady £112 odd a week, but they adjusted it up to 142 for reasons that they wouldn't share. Then the resource allocation panel, I'm thinking by then someone had threatened to bring judicial review proceedings, determined that this indicative budget was still too low and didn't properly meet the needs, especially in terms of meal preparation. And therefore her budget was put up to £170.45. She was notified of the amount she would receive, but not given reasons as to how this figure had been determined. And the defendant reassessed her again. And here's the cunning thing. They reassessed her needs to have increased substantially, yet they decided to keep the personal budget constant at £170.45 a week. So it appeared to be a cap, and that would be a fetter of discretion. So the barristers sought to argue that the resource allocation scheme's workings were unlawful. Rather than approach the costing in a linear way, it did it instead through a relative comparison way, and it matched points to the current distribution of people's care packages. And the barrister said that that wasn't what was required to meet an individual claimant's needs, and it kind of cut out the professional discretion altogether. The judge reviewed the government's guidance on resource allocation schemes and accepted the council's submission that despite their choosing to adopt this radical new approach, they had never ever accepted that the figure reached by the RAS was determinative. They were not telling themselves that they could just do what the RAS said. Instead, they'd use this figure as a starting point, indicative of likely costs of needs, but adapted through the panel. And that therefore meant that the individual's needs were properly considered and addressed, even though I think that that was probably under threat of litigation. So the judge formed the view that the resource allocation system adopted was not unlawful, went on to provide the victory for Mrs. Sava on other grounds that don't matter for the purposes of this lecture. But ultimately, the judge was saying that the RAS wasn't unlawful because the RAS decided nothing. It was just like a starter for 10, as it were, and there was still going to be human input. Well, we got a comment on our website in that era when we put it up, and it was this. It was from someone who said, as a non-lawyer, the resource allocation system seems akin to throwing the assessment and care planning and fair access to care services policy up in the air, and instead using proportional mathematics to drive the appearance of meeting of eligible needs or the duty to do so. And you can't disagree with that. But if it isn't the decision, if it's just a starter for 10, then you can't judicially review it. So then someone who's an academic called Lucy Series, she runs a blog called The Small Places. She did freedom of information applications to all councils and wrote an article on how the RASs of the early years were operating, and particularly how reluctant or incapable councils were of explaining how the hell they did operate. They couldn't, because the people who had created them were computer geeks who wouldn't tell them their trade secrets as to how the algorithm had been tested. But running forwards to 2014, they appeared in the Care Act guidance because most councils had spent money on one by then, so as to streamline decision-making to save on staff salaries, which were already running out because of austerity. So paragraph 11.4 of the guidance says this: it is vital that the process used to establish the personal budget is transparent. It says the allocation of a clear upfront indicative or ballpark allocation will help people to develop the plan and make appropriate choices over how their needs are met. Whereas the Care Act itself makes absolutely no mention of resource allocation systems or an indicative budget up front. This is pure policy, but it is a policy about a policy that doesn't decide anything. It is just a starter for 10. The Lewisham case was a case about a policy of not meeting nighttime care needs other than through PADs. Lewisham, who used to be really good at social care law, I'm not so sure these days, must have understood that the Elaine MacDonald case had been lost. And therefore, I think that senior management must have decided that if Kensington and Chelsea could provide nighttime care through PADs, then that's what their policy would be as well. Ultimately, providing for nighttime care through PADs is just another way of saying we don't do nighttime care. Ironically, I think if Kensington and Chelsea had ever been daft enough to say such a thing, then Miss MacDonald would have won her case, because it would have been a case on the fettering of assessment and care planning decision making. If you've got needs during the day that also occur at night, there's never been a law that says councils don't have to provide nighttime care. It's the problem is that they can choose how they meet needs, and they can do it cost effectively. And that's why people who need a lot of nighttime care get offered a care home placement anyway. Lewisham had decided that they weren't going to do nighttime care other than through pads. And therefore, that everybody was assessed as needing pads if they needed nighttime care. The judge agreed that a decision in terms of we don't do nighttime care, we provide pads instead, could not, as a matter of law, amount to an assessment complying with the Act, because it was just a generic decision relating to the management of incontinence, rather than one reflecting a consideration of the claimant's individual needs and well-being. So it was an unlawful policy. But what is really important is that by the time the case had wound its way to a conclusion, and the judge had very carefully read a number of rolling reassessments over the months that it took to get to court, the judge was satisfied that there was proper multidisciplinary input from both health and social work professionals, that the claimant had been fully involved, and that the clear regard had been had to all of the factors required for a lawful assessment, and that there had been no other non-compliance with the Act, regulations and guidance, or indeed no non-compliance with public law. So although a policy was unlawful at a high level, this is a case that shows that it is possible to arrive at the same conclusion if you just do it on a genuine case-by-case basis. This case, involving a lady called KK, is a court of protection case emphasizing that a capacitated person can choose to refuse residential care and stay at home, even if it's unwise, but can't make that decision until after a counsel has actually been courteous enough to say what offer it would make. And that offer must be lawful. It must be lawful to meet the needs that the person has or will have in that setting, given that the other setting was not necessarily inappropriate and just not wanted. And people will know, I'm sure, that local authorities tend to say this to themselves. They say, if we could offer a care home, but the person says thanks, but no thanks, well, that's their choice. So surely all we then have to offer them is the cost of that residential care home. They could have, the council says to itself, that's the person's choice. So therefore it must be legal to give them a sum of money. Hang on a minute, a sum of money that we know won't be adequate, even though the person is choosing to stay at home, it won't be adequate to meet the needs because we know what that will cost. What is that really like saying? It's like saying that the person has got capacity to choose to put up with less state care than they were first thinking that they were going to get. And it's putting that down to their choice. Whereas actually, if a local authority offers a care home and a capacitated person says no, the local authority is the one then that is making the choice, either to walk away because they don't have a duty to that person, or to toddle after that person and beg to be allowed to provide something. So if it's the local authority's choice, then the local authority needs then still to act properly under the Care Act and may not offer the person as much as they want, but still must offer as much as the person needs in the real world scenario that they are going to stay at home. And if a local authority doesn't do that, I think, and other lawyers too, think that they could be challenged. So in this case, the issue went one stage further. The lady was stuck in a care home and regarded as incapacitated, but the judge concluded that she did not lack capacity because she'd never been told the truth about what the local authority's duties were And the judge is a court of protection judge, so he couldn't talk in judicial review terms, but he said, the local authority must meet unmet eligible needs, even if that is in the cheapest feasible or practicable way. It can't just be in an all or nothing way or the cheapest. It can't just be an arbitrary way. It must be clear that about what is on offer. Otherwise, you can't find the person in the care home to be lacking in capacity, and therefore you can't stick them under a doles. So we derive from this in terms of public law that a council cannot legally limit a package of home care services, even for an individual, to a sum in the form of a direct payment or a package of care, if it's not thought to be adequate and appropriate, at least to meet the needs, were the person planning on staying in their own home. And that's very controversial because that's never been taken to court, even though it's happening all over the country. In a way, I derive some comfort from that because I think councils, lawyers know it too, because they don't let cases go to court about it in case a precedent is set. The Bromley case is an example of a commissioner who said no to a request to place a gentleman into a Hesley property without coming up with other alternatives. And in that case, Mr. Alloway won his case, albeit it wasn't under the Care Act, nothing has changed. The court found that the council had ruled out the Hesley village as too expensive and not justified, but without identifying any viable alternatives. So that was like saying, we won't pay for more than X pounds per week, even though it is our duty to meet needs. And that was said to be an unlawful fetter of discretion. So I think that that's why it says in the Care Act guidance now that there must be at least one placement that would work for the person before the personal budget that's been offered can even be regarded as justified. So that's interesting. This was the 2004 case. So Hargreaves on holidays must have been a 1990-something case. This is a reference to Luke Clements. He's an academic in this field and he's a solicitor as well. He writes up about the Rickson case, which we looked at in the context of following guidance and the obligation to follow guidance. But Luke goes further than that and looks at what the case actually involved. This was a case where the local authority needed to find day centre provision, but they couldn't find the specialist day service provision that would be needed for somebody like Jonathan. So they just stuck him on a waiting list and said, there ain't any. And the High Court said that that wasn't good enough. The authority had simply taken existing unavailability of facilities as an insuperable obstacle to any further attempt to make provision. So the lack of a day centre was a complete answer to the question of provision, and the judge said no. The judge said, firstly, any council that sticks somebody on a waiting list in this manner has to demonstrate that they're taking urgent steps to address the shortfall. And secondly, they have to demonstrate what they're doing in the interim before the ideal support becomes available. So this is an example of how you can forget what the cases are actually about once you know what principle they stand for. I was delighted to read this article by Luke Clements because I just think of Rickson as a case on the mandatory nature of guidance in all but exceptional cases. But it reminds me of how useful this case would be for somebody trying to deal with the absence of accommodation for somebody on the autistic spectrum, for instance. The fact that it doesn't exist doesn't mean that there's an excuse for not providing it or something in the meantime. So I think that that was really good. The judge said that it had to be flexible, and it had signally failed to do that. He goes on to consider the local authority should have put in place interim arrangements, and that local authorities will often have to loosen up. They'll have to increase their hourly rates or allow family members to be employed under a direct payment if they cannot otherwise meet the need. We just need some modern cases saying so. So the last couple of slides are just the paragraphs in the guidance where the word arbitrary is used. The government uses the warning not to make arbitrary cost caps in at least 4 places in the guidance, and it's in bold there. The authority should not set arbitrary upper limits on the costs it is willing to pay to meet needs through certain routes. Doing so would not deliver an approach that is person-centered or compatible with public law principles. The authority may take decisions on a case-by-case basis, etc., etc. In the guidance about calculating the personal budget, it says local authorities should not have arbitrary ceilings to personal budgets that result in people being forced to accept to move into care homes against their will. It can happen to people who lack capacity, but it cannot happen to people who have got capacity, because they are entitled to be told what the lowest practicable minimum to meet their needs in their own home is likely to be. In Annex A about choice of accommodation, it says that a local authority should not set arbitrary amounts or ceilings for particular types of accommodation that do not reflect a fair cost of care. The special aspects of a person have to be structured in. And the amount to be paid via a top-up all depends on the difference between the amount that the council was prepared to pay. So it says councils will identify a range of costs, and for the purposes of agreeing a top-up fee, the local authority must consider what personal budget it would have set at the time that the care was needed, not automatically defaulting to the cheapest rate or to any other arbitrary figure. Finally, making exceptions is an exhortation to local authorities to make exceptions to show that they're not fettering, and to make the exceptions rationally, not as a knee-jerk. Doing so is the whole point of strong management and person-centeredness. It is not weak to make an exception. It is actually strong. And making exceptions is not something that sets a precedent. So we just squeezed in between 2 o'clock. Any questions, please, from anybody? There may be some questions in the chat. Let me have a look. Jenny says, Kensington and Chelsea do say that they don't provide nighttime care unless funded by continuing healthcare. So, Jenny, all I can say of that is that somebody should be judicially reviewing them. Jenny said, and another Jenny, maybe the same Jenny, a different Jenny, said, Bristol are trying to cost cap. There are at least 4 or 5 councils at any one time that are trying to announce cost capping so as to manage people's expectations. Southampton has done it. Milton Keynes has done it. Lots of local authorities do it, but they never get judicially reviewed. And that must be because on an individual basis, they're afraid to do it. If I open up now the session, would people be interested in actually asking questions? Would anybody like to unmute? Madeline, hello. I know that that's not Madeline. That's actually John, isn't it? Hiya.
It's him again.
Hello.
It's him again. I thought I'd put my name in there anyway.
No worries.
Okay. Great chat as always, Belinda. So going back to this fettering of discretionary decision making, I picked up on the recreational activities piece that you were talking about within the holidays section.
Yep.
And this is just a sanity check, really, because I think I know the answer, and I think this is what you said, but I just wanted to check with you.
Yep.
Where, for example, it's been anecdotally demonstrated that a set of activities is crucial to relieve the burden on the person as a result of their disability, and that set of activities comes out at, say, cost A, for an arbitrary number, say it's £50 a week, but the council come back and say, no, we'll only give you £10 a week. Would that be a clear example of a fettering discretion?
Are you talking about disability-related expenditure, or are you talking about the
DRE.
care plan? Okay.
Yeah, it's in the care plan as well, but it's also become part of that DRE component.
Okay, so either something is paid for by the care plan or it isn't. So if you're saying that you need to spend the money on it, it can't be in the care plan. Are you saying that it's just mentioned in the care plan, but not covered by the care plan?
It's not paid for through the care plan.
That's
it's currently
the crucial
being,
thing. Okay, so I think that the Suffolk case makes it clear that lots of things that are being paid for out of people's benefits are being claimed for back again as DRE should actually be in the care plan. Okay.
Right.
So I think that you should go for the jugular and not just say that you think that there's a clear case that it is disability related expenditure such that their £10 a week standard policy isn't good enough. You should say that unless you are allowed more DRE back off of his charging assessment or her charging assessment, then you will be asking for a review and a revision to incorporate the activities as something that is funded by the care plan itself, because the evidence is so strong that it is needed. Does the person in question live in supported living?
Correct, yes.
Okay. So one of the problems was, in the old days, if the person was in a care home, it was a conclusive and comprehensive package that paid for all of the activities. Somebody's brilliant wheeze to shunt the cost onto the individual was to say, oh, once you're living in a tenancy, things that we assumed we had already paid for then become a question of choice, because you'll have so much more in your pocket rather than the personal expenses allowance.
Classic description.
Okay, so it's like I've got ESP, isn't it? The bottom line is that was just a massive national wheeling giant trend, and people fell for it. So DRE gives you an opportunity to push back, because anything taken off of the means test means that the council ultimately has less money coming in from you and the individual keeps more money. But equally, the Suffolk case says that you can push even further, because a local authority cannot treat activities, respite and holiday as being presumptively outside the scope of the Care Act.
Brilliant.
Okay.
Thank you, Belinda. That's really
good.
Great. Thank you very much. Appreciate that.
Mina, you've got your hand up. Hello.
Hi.
Hi. Yeah.
Yes, could I just ask a question? This hasn't actually happened, but my son has had 2 care assessments. One was face-to-face one. Sorry, not a face-to-face. One was a face assessment where there was clear questions that he could answer.
Yes.
Which I was happy with, but they carried out a new assessment without me being there. And it was a conversation-based assessment.
Okay, so
can I just ask, and it's coming, I'm going to challenge, I'd like to challenge this. Can I ask, because of my son's disabilities, that they shouldn't have given him a conversation one, because he just didn't understand the questions he was being asked? And can I insist that they do a new assessment, but a face one, so that the questions are clearly there, he can see what he's being asked to comment on?
Yes. We mustn't mix up face and face-to-face, okay?
Yes. Okay.
A face-to-face assessment is one where the person is in a conversation with another person. So a face assessment is a name for the type of resource allocation system that was sold to local authorities. It was called FACE.
Yeah.
Now, there are many councils who have given up using that because
Okay.
basically they bought into them to drive the cost of care down. But now
Okay.
the cost of care has gone up. They're terrified to use them because they would have to acknowledge that the figures driving the outcome figure have to be put up. So
Okay.
the idea that you have the 3 conversations is meant to be a respectable progression away from using face assessments. But as you have so conspicuously noticed, it hasn't done your son any good because he didn't understand a word of it and you weren't involved.
Yes.
So your question as to whether you are entitled to a face assessment is no, because you have to have the kind of assessment that a council is doing. But you can say that the conversation is not compliant with the Care Act.
Okay.
Because it isn't doing what a care assessment should do.
Okay.
All right.
Thank you. Thank you very much. Thanks.
Okay. Then Mary, do you have a question?
Yes, please. It's just this, there's this new system whereby councils have backlog, so they employ, they outsource to some agencies that interview people over the web on the Zoom.
Yep.
And then they go away and write reports. How long should the review assessment take in order to get good detailed information and reports?
Okay, nobody can say how long an assessment should take, because an assessment will always depend on the individual's range of problems. If you're saying to me, is it legal to assess online? I am going to say, yes, it is in the vast majority of cases. You might say 80% of cases. In 20% of cases, it won't be. Because if a professional was honest, they would say that there's something about that client or that client's family or that client's environment that makes their antennae wobble, you know, and they're only going to be able to do a proper evaluation if they physically go.
No, they actually say they must do the assessment within 1 day or 24 hours. They do the assessment and then report has to be ready within 24 hours. For
well,
this.
they're probably using artificial intelligence to make the type of prose that they're putting in very standard. So, I mean, I'm not dissing any particular company. I am just saying that that is the way we are headed. And it is the only way, unless we get a new government which actually injects more money into social services, not just social care, but social services, it's the only way that there will be enough assessors to go around. I've got no problem with the idea of an assessor being assisted through technology to do the report more quickly. But if it is just a chatbot writing the report, you know, because 17 key words have been put in by the assessor, then that should be challenged, just like a face assessment could have been challenged, or a conversation could have been challenged. Because the bottom line is,
it's inhumane, everything that they are doing now.
Yeah, it does. Inhumanity is not a test under the Care Act. Defensibility, is it defensibly compliant, is the test under the Care Act. I'm sorry to say. Okay. So
yeah, thank you very much.
Yeah. All right then. So we've gone on a bit long today, so I'm sorry about that, but it's an important session. Excellent. All right then. Thank you very much indeed, everybody. Cheers. Bye-bye. Bye.
Thank you. Yeah.
Thank you.